Please join me as I welcome tonight Dr. Enejo Abdul, the Assistant Registrar and Head of Department of Professional Discipline, Medical and Data Council of Nigeria. You are very much welcome, sir.
Thank you very much. It's my pleasure to be with you this evening. I'm pleasantly surprised at the level of interest this topic has elicited. I got people that I've not spoken to in a long time calling to ask about the lecture. So thank you for the opportunity to speak on this topic. The president, Dr. Monye, very senior medical practitioners present, the ones I can recognize immediately. I can see Professor Lokoba, good evening, sir. Dr. Olani Johnson, good evening. I just need to point it out that it is appropriate as part of the code of ethics. In every situation you find senior colleagues, you must recognize them and accord them respect. So please, those I don't recognize, pardon me. It's because the screen is not so big. I can just see a few names that I recognize. Thank you. If you permit me, can I go ahead?
You can go ahead, sir.
Okay. Okay, I'm supposed to share my screen, right?
Yes, sir.
Okay. I'm sharing it now. Okay, you can see it. Okay. I hope you can hear me.
Yes, sir. We can hear you, sir.
We can, sir.
Okay, you know the problem with this Zoom, you don't get immediate feedback, so you don't know whether you can be heard or not. We'll go through with this outline, the protocols. We've done that. We'll do an introduction, and we go through the topic like this. I can see I have just 25 minutes, so I'll try to be fast while not missing out important details. I need to do a disclaimer. I'm not a lawyer. You see that I'm a member of the World Association of Medical Law. That doesn't make me a lawyer. You can be a member if you're interested in law. You're either a lawyer or a doctor who is interested in law. I'm a medical practitioner who is interested in law, especially as it concerns the practice of medicine. I work at the council. However, I do not speak for the council. So whatever I say here shall not be construed as representing the official position of the council. And this is only a discussion between colleagues for the purpose of enlightenment. I think this needs to be clarified. Now, we all know, if you've been following, especially if you're a medical practitioner, you know that negative tourism, that is medical tourism, that is whereby people leave the country to seek healthcare, medical services elsewhere, as against positive tourism, medical tourism, where people come in to access medical services here. What we have is a net negative tourism, and it is a big problem in Nigeria. We travel to several countries seeking medical services. While I was at Kano, people actually go to Niger to get some services there, though that's a bit extreme. Now, aside from the attendance capital flight out of our economy, a lot of our citizens are also subjected to sharp practices with deleterious effects on their health and financial well-being. I will not mention the country, but I'm sure when I say this, a particular country comes to mind. A lot of the healthcare services and expertise Nigerians spend billions of naira to access abroad are available here. And it has been suggested that a lot of our countrymen are not aware of the availability of such expertise or services in the country. And the lack of information in the public domain on the availability and location of the services and expertise in our country is stated as one of the causes of negative tourism. It is clear to all of us, especially at least if you're a doctor and a dentist in Nigeria, that advertisement is abhorred by the professions. I'm sure it is part of why people are so interested in the topics. So we'll look at these definitions. There's publicity, which is public visibility or awareness for any product, service, or company. It may refer to the movement of information from its source to the general public, often, but not always, via the media. The subject of publicity includes people, goods and services, organizations, and works of art or entertainment. While advertisement, on the other hand, is a notice or announcement in a public medium promoting a product, service, or event. So if you look at it, publicity is you are making people aware of a product, a service, or a company, while advertisement is an extension of publicity. Aside from just making people aware, you are promoting that service. Registered medical practitioner. This is a person who is registered under the Medical and Dental Practitioners Act by the MDCN as a medical practitioner or a dental surgeon. These are the persons that are covered by the regulations made by the Medical and Dental Council. I needed to point this out because in the course of discussion, even among doctors, when you talk of medical practitioners, you hear nurses and pharmacists including themselves in that category. They are not medical practitioners. They are healthcare practitioners. Now, healthcare institutions like hospitals, clinics, diagnosis centers, rehabilitation centers, and etc. are usually set up as strict business enterprises or limited liability companies registered under the law. This is becoming more and more common. In fact, recently I found one of the regulations for a farmer for a facility to be registered by them is the facility must have registration by the Corporate Affairs Commission. So that makes those bodies registered businesses. And when set up as such, they are juristic persons who can sue or be sued. However, this juristic personality does not make them registered practitioners as construed under the Medical and Dental Practitioners Act. And as such, they are not directly subject to the regulations on advertisement made pursuant to the Act. This is tantalizing, I'm sure, but you need to take it with great caution, as you will see as we progress. Health institutions can also be set up without registration as strict businesses under the law. They are not juristic persons. They are legally an extension of the owner of the practice. So they assume that person's legal personality. So the person who cover for their infractions, typically those ones fall under, that is the activity of the hospital is deemed to be the activity of the doctor running that hospital. Advertisement in medical practice. Like I said earlier, doctors and dentists are legally subject to the regulations made pursuant to the Medical and Dental Practitioners Act. And for the purpose of this discussion, Section 1, Subsection 2, Paragraph C of the Act is relevant. It's reproduced here for ease of reference. And it says, one of the functions of the council is reviewing and preparing from time to time a statement as to the code of conduct which the council considers desirable for the practice of the professions in Nigeria. The provision above is given effect in the form of the Code of Medical Ethics in Nigeria, which is published periodically. The extant code is the 2008 edition. That is kind of the book that contains what a doctor can be found guilty of, what we say misconduct in a professional respect. Violation of that code is what may be deemed as infamous conduct in a professional respect. The regulations on advertisement are contained in the code in rules 14.1 and 54 to 57 of the code. And I realize this discontinuity kind of is what creates the confusion doctors have. When doctors want to look up the code on anything related to advertisement, they go to 54 to 57, which actually deals with the practitioner himself. 14.1 deals with the institution and the relationship of the practitioner with that institution. So the practitioner and the institution, every practitioner who is connected or involved with a limited or publicly quoted organization providing clinical, diagnostic, medical advisory services, such as public or private clinics, etc., whether as partner, director, employer, consultant, or in whatever capacity in which their status as medical or dental practitioner would be clearly construed to lend support or foster the activities of the organization, have the responsibility to ensure that the provisions of the Code of Medical Ethics in Nigeria are complied with. Such institutions can publish information on the services offered by them in the print and electronic media and even on the internet. Note the institution that is a registered business under the law that has juristic personality can publish information on the services offered by them in the print and electronic media and even on the internet. This information should not feature the names, qualification, and expertise of specific practitioners. So what you see where you see Hospital ABC, directors, Dr. XYZ, who went to Imperial College London, has so and so and so and so. That is not correct. Advertisement from such organizations should be factual and not promote in any way the professional qualities or services of identified individual practitioners connected with such organization, or make unfavorable comparison or allusion to the services offered by other organizations, whether public or private. Simply state what you do. You are not the best. You are not the most prolific. All those superlative terms may be an infringement or infringe on the confidentiality of patients who use the services of the organization. This needs to be emphasized. You see this commonly with facilities that are engaged in IVF or assisted reproductive technology, where you see pictures of a smiling mother with babies and all that. That is a violation of their confidentiality. It does not matter even if they gave you consent. Because if you look at the code on consent, on confidentiality, even under court order, the code says you should reluctantly give information on your patient and you should give the barest minimum that is acceptable. So putting up your patients to show your success may not be acceptable. And they should also not mislead patients, entice them with promotional materials, or interfere in any way with their rights to referral. Where you see independence promo, you do 6 cycles for this amount of money and all that. That is promotion and is a violation. Patients' information leaflet listing services provided and possibly the timetable for such services may be distributed to attending patients and their relatives, or may be displayed conspicuously within the premises of the facility. Care must be taken to ensure that what is publicized in such information leaflet is only services offered by the institution and not the doctors. The institution, not the doctors, not their qualification or their specific individual skills and competence. You do not have the best surgeon or the best orthopedic surgeon and all those superlatives related to specific doctors. That is individual identifiable doctors. Practitioners should not directly be involved in promoting the services of such organizations through such practices as public speaking, broadcasting, signing circulars, writing articles, putting publications in the information media and the internet, and permitting the use of their photographs and professional qualifications in promotional activities of such organizations. Now, doctors in administrative charge of health institutions may grant interviews or make media releases in respect of the institution they manage. For example, there is a private facility, a big one in Abuja, that is involved in kidney transplant, for example. This provision says that the doctor in charge of that hospital could announce, we achieved so and so and so in this hospital on this day and all that, to the extent that they do not use it as an opportunity to call specifically call attention to themselves or their professional competence. That is, that person in charge is just talking about the hospital, not about himself or herself. Now, self-advertisement, that is the one that is a problem. And self-advertisement by registered practitioners is prohibited. It is a long-standing tradition of the medical profession that doctors should refrain from self-advertisement. This goes a long, long way. In fact, in some parts, you see where some people say that advertising and not advertising is the difference between quacks and non-quacks. The word quack actually is said to have been derived from the fact that charlatans have to make quacking sounds to attract people's attention to their snake oil and all the charms they sell. While a doctor is dignified, the patient seeks him out and asks him to attend to him, submit himself to the doctor without the doctor looking for him, as the other way around. You'll find that even in the United States of America, where the doctors are permitted to advertise, the downside of their own is if you advertise and you give information that is incorrect and it leads to harm to the patient, you don't just get deregistered, you could land in jail. Even though the American Medical Association opposed it when the Federal Trade Commission said that prohibiting doctors from advertising was impeding trade. They opposed it, and if you check, in 1975, I think it had to go to the Supreme Court, where the Supreme Court ruled in favor of the Federal Trade Commission. So the agreement was you allow doctors to advertise on the condition that what they advertise is accurate and it is true and is not misleading. Now for us, the prohibition of self-advertisement has been so because of the appreciation of the profession that advertising could become a source of danger to the public, in that a doctor who was successful at advertising himself might not in fact be the most appropriate doctor for a patient to consult. That does not need emphasis. Typically, the loudest person is not necessarily the one with the best content. The charge of self-advertisement may arise if it is shown that a doctor advertised himself directly or indirectly for the purpose of obtaining patients or promoting his professional advantage. practices commending or directing attention to his skill, knowledge, services, or qualifications, or deprecating those of other doctors. Is associated with or employed by those who sanction such advertisement or publication. Canvassed or employed any agent or canvasser for the purpose of obtaining patients, or is associated with or employed by those who employ the services of such agents or canvassers. Unfortunately, a doctor, out of respect for him, I will not mention his name, even though there is no legal impediment to that, was found guilty by the tribunal of self-advertisement, unfortunately, and it was unfortunate. Now, the court's adjudicator rules, which serve as parameters for determining the culpability of a doctor who becomes subject of proceedings on a charge of self-advertisement. The panel, that is the Medical and Interpractitioners Investigation Panel on the one hand, and if it gets to the tribunal, the disciplinary tribunal, will determine whether the content of the said advertisement did indeed advertise the defendant doctor, whether the practitioner has been credited with exceptional abilities or qualities which made him stand out from among his colleagues, whether the said advertisement was traceable directly or indirectly to the defendant doctor, or whether a complete disassociation from the offending publication to show that he did not procure, sanction, or acquiesce to the publication, or if he did, whether this rebuttal or disassociation was published promptly and in good faith. You can just do a perfunctory rebuttal. They will check whether it was done in good faith or not. So in conclusion, I would say that the regulatory framework in place allows publicity and advertisement of health facilities and services in a manner that is not harmful to the public or deleterious to the image and reputation of the medical and dental professions. Whereas what is prohibited is self-advertisement by practitioners. Thank you very much.
Thank you very much, sir. Thank you for the presentation. Please confirm you can hear me.
I can hear you.
Okay. Thank you very much once again. And for the panelists, if you can unmute, I would just like us to give a round of applause to our presenter. Thank you so much. And I see the virtual applause also. Thank you, Sam.
Thank you.
So we'll go straight up to the question and answer session. Thank you for keeping it succinct, and I'm sure that all the points were noted. So the first question from Abbas Rabiu Mohammed says, thank you so much for organizing such an important presentation. Okay, so he's asking for the PowerPoint presentation. I guess we would have to seek your permission, sir, to have this shared, but we'll get back to the participants on this very important question. So secondly, the next question says, ignorance about availability of specialist services is responsible for negative medical tourism. How can we hold this if advertisements or awareness creation by health institutions is abhorred in Nigeria? So, sir, can you throw more light on this? I know that you...
I had said the institutions, what is important is that the institution is a juristic person. Either it is registered under the corporate affairs commission, and it is a going concern that can sue and be sued. It can advertise, I pointed that out, it can advertise and publicize its services. It can even advertise the expertise available. The condition is that they will not focus on individual identifiable practitioners. So for example, if you have the services of, say, a brain and spine surgeon, for example, nothing says that the hospital cannot advertise that. What they cannot advertise is who that surgeon is. You cannot say Dr. ABC, our expert brain and spine surgeon, blah, blah, blah. No, you can, the hospital can, or the institution can advertise their services. You can check that up in the code, is a rule 14, rule 14.1a of the code.
Okay, thank you very much, sir. I think the more you speak about it, the clearer it becomes. So that question was from Stephen Anzaku, and thank you for your question, and thank you, sir, for making it clearer. Now, Folu Olaniyi George, we want to know if there is supposed to be a time frame to the periodic review of the Code of Ethics.
Okay, the Act did not place a time frame. However, yes, the code is due for review. It is actually in the process of being reviewed.
Okay, I seem to think that there may be some more questions with this, Fulu. So if you have another question, I'm trying to imagine that there may be a reason for asking. I'll just be silent on that. So Stephen again says, okay, sir, okay, please go on.
No, you could say the reason that the provisions on advertisement need to be updated, right?
It seems so.
We are in the process of doing that.
Okay, and I'll probably
but until that is done and it is passed, the advice is stick with the extant provision. The extant provision is what is the law for now.
Okay, thank you, sir, again. Again, Stephen says, what can the Ministry of Health or MDCN do to halt negative medical tourism in Nigeria? I would like to just say that this is really not directly related to our topic, but would you want to say something about that, sir?
No, I will adopt what you said.
Okay, thank you very much. Now, what's the place of social media postings that directly or indirectly seem to advertise self?
Social media postings. For example, you post something on your WhatsApp status.
Facebook, Twitter, WhatsApp status, Instagram.
Yes, as a doctor, you are in violation because you are aiding the institution. Even if you are doing it for the institution, you are aiding the institution in advertising. One, if you are doing it for yourself, you are engaging in self-advertisement. If a non-doctor, typically is the admin officer or receptionist or somebody, posts, and that post includes you and you are identifiable in such posts, it is a violation.
Okay, thank you, sir. That's also clear. So we'll go to the next question. And now someone is asking, what of advertisements for free medical treatments? What are the rules?
It still boils down to advertisement. Let me try to explain it this way. A patient should not come to a particular health facility because he's attracted by an advantage or a benefit other than the fact that he is seeking a medical service there. If you are providing free medical services and you announced it, and that is the reason why people came to you, which we know that a lot of people use that as a means of recruiting patients. People come, they tell them they get free medical services. When they come, they check their BP, they do fasting blood sugar for them, and the person is told he has a problem. That problem, he needs to pay for it. Now he has been ensnared. He's in the hospital. He has a problem which he wasn't aware of. Of course, he becomes a patient. That is enticement. But the mere fact of you are putting up something, which is what is attracting the patients, whether it is free or you are providing services below the going rate. If, for example, something is 100,000 and you are providing it for 10,000, of course, people will want to come to access it. That does not say you cannot provide free services. However, it should be that when the person comes, he didn't come because he's seeking free service, but he came and found out that you are providing free services. That's a different matter. He goes back and tells his people, okay, there is this going on in this hospital, and they come. That's different. Whether you put it on radio or you put it in the newspaper or you put it in social media, that you are providing on so and so and so date, which you see quite frequently, that is not acceptable.
Thank you very much, sir. Rich insights, and we have quite a number of questions. I'll just go on and go on and on until we exhaust as much as we can. So the next question is, what about a situation where a public health facility mentions the hierarchy of its medical practitioners? Can this be seen as advertisements?
Mentions the hierarchy. Are you talking about nominal rule? Or the question is not clear anyway.
Okay, so I would want to imagine, well, I really, maybe if we have maybe residents, senior registrars, or registrars, senior registrars, consultants, and maybe among the consultants,
inside the hospital?
Some form of hierarchy.
Inside
the hospital, but as an advertisement to external parties.
Well, what is important is you do not attract specific attention to identifiable practitioners. But if you say you have 10 consultant nephrologists, for example, and who are training 50 residents, that's not a violation.
Okay, so Peter Bulus asked the question. If you would want to throw more light on the question, if it hasn't been answered to your satisfaction, you could please throw more light while we move to other questions. Thank you so much, sir. And Chinedu Franklin Obia Jemba says, what is the required signboard dimensions for private hospitals? Is the use of neon signboard prohibited? Is it wrong to list the services like maternity, ultrasound, etc. on the signboard?
Inside the hospital, it is not wrong. If you have the hospital is in its own premise, you have your signboard and the signboard is inside the hospital, there's nothing wrong with it. It is there in the code.
Okay, so the second part is the required signboard dimensions for a private hospital. Would you want to say something on that?
I do not readily remember the dimensions, but they are provided in the code. I think that will be around 56 or so.
Okay, thank you so much, sir, again.
Now, sorry, let me just expatiate on that. The signage, if the hospital is it owns the whole building and the compound, they can put signages inside the compound, a signboard or whatever. But if it is a clinic that is sharing facility or other bodies there. The provision is that the sign is a plaque on the wall of that clinic. That's what the provision is. I hear my internet is unstable. Can you hear me?
Yes, I can hear you, sir. Hello, sir.
Can you hear me?
Yes, I can hear you.
Okay.
Okay, so please, thank you so much. I'll go on with the questions.
Okay. The questions are so many.
There are so many, yes. So Dr. Christian Makwe says, I want to know if the upload of your bio sketch with qualifications and picture in a public health institution's website is a violation. This is because my tertiary institution is updating their website and requested for our personal bio sketch.
From what I've said so far, and if you check the code, it is a violation. You check the code, rule 14.1, rule 54 to 57. You see that it's a violation.
Yes, I think that is also why Foluke Olani George asked the question about updating the code. She's also saying that it was 2008 edition. If there is no regular review, we run the risk of living or practicing behind the times. But okay. Thank you for the answer, though. And I'm sure that is also in the minds of so many of us here. So another person says, Ayodele Ojua says, what is the place of practitioners carrying and distributing business cards? Is this allowed?
Business cards. Who do you give the cards to? Because if you check the code, if you are in the habit of giving your cards to people who will distribute them to others as a means of letting them know where you are, that is the touting and canvassing we are talking about. But having a complimentary card for the sake of interaction with people, there's nothing wrong with that.
Okay, thank you, sir. That's well taken. Said Juma is asking, he says, what's the position of the code with regards to a medical practitioner being used for an advert or a brand ambassador for a non-medical or professional institution?
Is the person identifiable as a doctor? If he's identifiable as a doctor, no, it is not acceptable. But if he's there as he's not acting as a doctor, he's not an ambassador because he's a doctor, he's there because he's him, not because he's a doctor. And what he's doing does not relate to being a doctor. It's not a problem. But if you're a brand ambassador, of course, they won't just give you brand ambassador just so that you say you're a brand ambassador. There will be other superlatives that will come with it. You are the best, this best that typically they would have given you an award as a doctor. Then you are aiding to advertise that the brand or the institution, which from the foregoing presentation, you see that is the violation.
Okay. I think that's also taken and clear. I may be skipping some questions because they are similar so that we can run through most of the questions. Now, something peculiar. Someone says most private clinics advertise their services online with hours of service, locations, and sometimes clinical pictures of their cases seen. So you had said, of course, online, you've said, for now, not permitted. But what is particular is with clinical pictures. That also seems to be a violation, but sir, can you throw more light on this?
You've said it is a violation. It's a violation, especially when you expose the patient is identifiable and all that. Anyway, like I said, I will, out of respect for the doctor, I will not mention it, because that would have been a very good example of what these clinical pictures and all that. It is a violation.
Okay, thank you, sir. Thank you so much. So someone again is asking, most advertisements on dental procedures are done by non-dentists. Unfortunately, they get away because of a lacuna in the law. Isn't that inimical to the development of the practice when more competent specialists are not visible? So other non-medical persons are advertising, and those who have the skills cannot advertise.
And that's the difference between you and them. You are not in competition with quacks. You are not in competition with quacks. Never lose sight of that fact. You are a doctor practicing medicine. A quack is a charlatan waiting for the day he will be arrested and prosecuted. That is one. On the other hand, there is the broadcasting code, and broadcasting code is clear. Any body that is going to broadcast information that is medical should ensure that it is cleared by a medical practitioner or a dental surgeon as accurate before they broadcast it. So if you see a person advertising anything about dental care, of course, it's not a doctor. That is a way of avoiding sanctions for the dentist. But if what he is saying is wrong, or he's presenting himself as a doctor, then he's in violation. And the first thing to do is report it to the National Broadcasting Commission, because they have a provision for that in their broadcasting code. And they will sanction the TV or the radio or whoever broadcast it. Thank you.
Thank you, sir. I'm wondering if you have a glass of water by your side just to rehydrate, or can I go on, sir? The questions seem to be rolling in. So Chinedu also says MGCN does register alternative healthcare providers and says their kind of advertisement is vulgar. Why is MGCN not clamping on them?
Good question. One, MDCN does not register alternative medicine providers. MDCN registers alternative medicine practitioners. An alternative medicine recognized by the Medical and Dental Practitioners Act are 4: homeopathy, acupuncture, naturopathy, and osteopathy. They are not up to 40 of them that are registered in Nigeria. So Yemkem and all people like him are not registered by MDC, and we have no business with them. Those people are police property. The day police decides to arrest them for whatever, they'll prosecute them if they are interested, and they'll successfully prosecute them. There is no person that is registered by MDCN that is doing what those people are doing. Thank you.
Thank you, sir. So I'll read out this, but I know you've answered it before. Displaying babies delivered in your facility on Facebook, is it advertisement? So there are two issues here.
It is advertisement,
The
is
confidentiality, yes.
One, advertisement two, and even possible self-advertisement, because typically you see the doctor's picture there too. It's a violation.
Yes, sir. You actually mentioned that in your presentation, yes, clearly.
Yeah, a doctor got cumulative 12-month suspension, even though they were running concurrently for something like that very recently. So if you are doing it, you are only free because you've not been reported and we've not seen you. Okay, I'm listening to the next question.
Yes, I'm trying to sieve them out so that I'm not repeating questions. So now someone says the website of certain hospitals have the list and specialty of their staff, including doctors, posted on the site. Is this wrong? So apart from
I didn't get that.
The websites of certain hospitals have the list and specialty of their staff, including doctors, posted on the site. Is this wrong as well?
It is wrong if, of course, if a doctor is identifiable as Dr. ABC, a specialist in this, that you're advertising him and his skills and qualifications. It is wrong. Sorry, I'm looking at the questions. There's this question by Sarah Beckley. Have you seen it? Something about, you mentioned Hefama, Lagos State. In Lagos State, are they allowed to close down hospitals based on social media rants against hospitals?
Against hospitals.
Yeah, the tail end of the question is what I don't understand. Social media rants by who?
Okay, so Sarah Beckley, please, if you can expatiate on your question, we'll take your question again. She noted that it's actually not directly related to the presentation.
Yes.
So Professor Austin Ojabo wants to know, why is it that MDCN seems to be particularly eager to sanction erring medical practitioners, but same is not being done to other health practitioners? I think you've talked about this, but it says, for example, we see patients with lots of, we see patients with lots of complications after being mismanaged by nurses, pharmacists, lab scientists, yet nothing is done to such health practitioners.
MDCN has jurisdiction over doctors, dentists, and alternative medicine practitioners that are registered. It is actually a privilege for a doctor that is registered who is accused of doing something to appear before the disciplinary organs, because ordinarily, but for his registration, if it becomes a subject of inquiry, it will be a criminal thing. So those nurses, pharmacists, and co, they are committing an offense, and ordinarily they should be reported to the police. Because a pharmacist, a nurse, put nurses aside, pharmacists, medical laboratory scientists, dental therapists, optometrists, and all the likes, physiotherapists who pretend to be doctors and attend to patients. It is even more rampant with pharmacists who claim that they are doing community pharmacy. They consult, prescribe, and dispense drugs to patients. It is an offense. Now, the question you ask is, what is MDCN doing about it? It is not MDCN's function. What MDCN's function is if it becomes a matter of criminal prosecution, that is what it's supposed to be. And it is police that is supposed to conduct that investigation. If they have evidence they can sustain in court, they give it to the Director of Public Prosecution of that state to prosecute the person. Now, what MECN will do if they are called as witness is to show evidence that this person is not registered as a medical practitioner. And because he's not registered as a medical practitioner, he is not permitted to do what he did under the law. It's Lagos that is attempting to go in that direction recently. But it is a matter for the states to deal with. For those who are conversant with the law, under the Constitution, Section 251 of the Constitution, a lot of these criminal offenses are supposed to be prosecuted by the state, the Attorney General of the state. It is a few federal laws that are prosecuted by the Attorney General of the Federation, or if the crime is committed in the FCT, then the Attorney General of the Federation can also prosecute because it's also the Attorney General of the FCT.
Thank you, sir.
I don't know if that is clear.
Yes, it is clear. Thank you, sir. So most of these questions are actually around social media posts, and you've made it clear that yes, that's a violation. So I won't go to read specific questions, but someone is asking about calendars and diaries. So let me just go back to that. What of printing calendars, diaries, and other customized gift items, especially those with pictures? Example, their surgeon operating in the theater.
By the extant code, that is a violation. That is a violation by the extant code of medical ethics. It is a violation. And I believe it will even remain in the new one that will come out.
Okay, just a comment from Choma Miruko. She says, are these advertisement codes reviewed periodically or are they cast in stone? They sound too rigid. So I'm sure that the next review will take care of that. Okay.
They are not cast in stone. Even the Constitution is not cast in stone.
Okay. And so someone else is asking, Dolamo is saying, you talked about billboards being acceptable within the facility. What about billboards on the roadside and banners on electrical poles? Is this acceptable?
No, it's not acceptable.
Okay. Another very, also which has been on for a while, can a doctor advertise supplements he believes in? Recently, a doctor advertised eye supplement for glaucoma and cataracts, watery eyes. I don't know if that is actually part of this lecture, but sir, if you can throw more light on this, that would be good.
Not part of this lecture because that is malpractice. It is malpractice that you believe in it. There's a way of if you discover any treatment, either it is a drug or a procedure, there's a way of presenting it to the body or the profession for it to be validated by others and admitted into the mainstream. Not that you go and you start, because you believe in it, in quote, you start using it straight ahead. In fact, it's one of the few exceptions where we can proceed against the doctor without waiting for anybody to complain. If it comes to our attention, we can proceed against the person without bothering to wait for anybody to complain. As against the vast majority of other offenses, somebody has to complain before we can take action.
Okay. Thank you so much, sir.